Good evening, everyone. We hope you are well. My name is Lauren Maxey. I'm one of the attorneys at NC Planning here with Mr. Kyle Frizzell. We appreciate y'all taking the time. Today we are talking about the probate puzzle. Excited. We have some people that are still calling in, still joining via any meeting. To start things off, I want to give you a little tour of the software, point out a few helpful tips and tricks if it's your first time using any meeting. It's got some interesting features. There is an attendee chat. That is a private feature. So that is just chatting with our team. The wonderful Kajua and Andrina from our team are fielding questions and items. So if you have a particular question throughout the presentation, need anything at all, just pull up that attendee chat you see on the left-hand side of your screen, type it in, and they'll take good care of you. You should have also received an email prior to this presentation with lots of helpful handouts for your information. We're going to be referencing a lot of those handouts in this presentation, so be sure you have that most recent email up. We did change some of them, add some new ones. So make sure you've got that up. And if you don't have that, just again, in the attendee chat, let us know, hey, can you resend that email with those handouts? They'll take good care of you, chat your email address, and they'll send that right over to you so you can pull it up. Openly, we want today to be as beneficial as possible for everyone. So this is meant to be a practical workshop. On our attendee list, I do see we've got some lovely past clients. Thank you for joining us here today. Some ongoing clients as well, and then some financial advisors that are interested in more knowledge on this topic as well. So again, happy to help in any way we can. Give us a shout through the attendee chat. And then you also have some little emoticons, I suppose, if you want to tell us how you're feeling. Hopefully we won't get any sad crying faces. We'll try to avoid that, or any thumbs downs. But we're going to have some fun today. It is meant to be interactive. There's going to be some polls and handouts and things that we'll touch on. But I'm going to let Kyle tell you a little bit about our team if you were not a past client, learning a little more about NC Planning.
Yeah, thanks, Lauren. We're really excited that everybody is here. I'm going to try to take over this. I don't know, Lauren, the slideshow might want you to advance it now that we've started.
Oh, let me see here. Maybe Elizabeth can do that for us if she's with us.
These are the things that happen when we do a webinar.
Oh, right? The joys of technology.
We have to figure out the technology piece of it.
But yeah, we can go on with telling a little. We'll want to get that. I'll deal with that if you want to tell a little bit about NC Planning. Oh, there we go.
I think we got that.
Perfect.
Yeah. So now that we have something on the screen in front of us, we are NC Planning. We are a law firm, for those of you who may not know that. And you'll see some bullets on the screen. Basically, the first one that I like to start with is that we like to take a team-based approach to legal planning. What we mean by that is, yes, we work closely as an internal team. We want to make sure that everybody is pointed in the right direction and doing the right thing for our clients. But we also like to work with your team. And what that means is working with your financial advisor, your CPAs. So whether it be on something like what we're talking about tonight, an estate administration, working on estate plans, working on business planning, just trying to make sure that all the horses are pulling the cart the same way, everybody's circled up and we know what we're doing. Basically what I like to say here, you'll see that we've got at the very bottom of that list, we like to do things on a fixed fee structure. Most of the time, I'd say 9 times out of 10, when you sit down and have a meeting with us, we should be able to quote you a fixed fee by the end of that meeting. What I'll say though, we are talking about estate administration this evening. It is notoriously hourly work. clerks of court, especially if we are dealing with a full estate administration, prefer to see hourly billing. We have worked and tried to figure out how to do fixed fees on that. Hard to do because all of these are different, and I think that you'll notice that tonight as we talk through this. This process can take a whole lot of different ways, a whole host of different paths. Um, and so, again, on this side of things, the fixed fee structure, not as often.
Yeah.
But let's see. The
And then I'll advance. Oh, we're both advancing now. I got
We've got everybody trying it. So the next piece of this, though, we do have a little disclaimer for you guys. We are lawyers, and so we like this kind of stuff. But I'm not going to read this entire thing for you. Bottom line here, this is just for your information. This is not to be construed as individual legal advice. We are, and you'll probably get some messages throughout the night if you ask a question, doing some one-on-one consultations that are complimentary through this. If you've set one of those up, we will review some of your individual information and determine whether an engagement is necessary. But bottom line here, just tonight's all about getting some information, hopefully pointing you guys in the right direction if you are administering an estate or if you're named in someone's estate plan. We just want to make sure that we're giving you good information, and you know that this doesn't start an attorney-client relationship, and that's what all this language on your screen is about.
Thank you, Kyle. Yeah, it is something where these matters are so unique. As you're going to hear in this presentation, there are so many different factors that can work their way into what is the best option for the administration, what's the cleanest, simplest way of getting from point A to point B. So very individualized discussion. Again, that's one of the reasons we're offering those complimentary calls with attendees today. So if you haven't touched on that, if you haven't taken us up on that offer, attendee chat, say, hey, I'd love to have a 30-minute call with Lauren or Kyle. Most people like to talk to Kyle, but I'm happy to chat too. And we'll have a private discussion, assess your individual questions there. But to get a feel for who is attending today, I'm sending out a little poll, and I've got that up now. So to share with us, what got you interested in today? So you can be able to click on this of, I'm currently serving as administrator or executor. I was named as an executor, but I'm not yet serving. I'm just curious as to what that means. Or I'm interested in helpful tips and tricks for my own planning to make things easier for my executor. So are you currently serving as executor or administrator? Are you named but not yet serving? Or are you trying to make it easier on those that are named under your plan? So we've got a few results in here. I'm going to share that with y'all. Kind of interesting. A lot of individuals looking for helpful tips and tricks. That's great. We've got a lot of those coming your way tonight. Some individuals that are named and not serving yet, and one individual that is currently serving, it looks like. God bless you. We'd be happy to answer some questions here today. This, again, knowledge is power with this stuff. So we're really going to focus on those practical tips and tricks for everyone. And we'll kind of take it from there. So let's kind of jump into things. And again, making sure you've got your handouts and information up. We just did our first poll. We want this to be interactive. We want to make sure this is actually beneficial for you. It's really tough with these little video chats. Normally when Kyle and I are doing presentations, we're up and making eye contact with attendees, and we can kind of know if you're with us or if there's just blank stares. So again, chat away at us. Andrina, Kajua are fielding that attendee chat. Do not hesitate if there's questions. So again, let's kind of just jump into it. We're going to start with some of the most frequently asked questions after someone's passing. It's part of our process. We get those calls. So it is one of those things. We touch base with clients. These are some of the most frequently things that we're talking about in the very early stages. So one, is there a will? Again, if someone's calling us, they've been named, or they're trying to take care of a loved one's estate. Was there a will? Was there not a will? Can we find one? Who are the beneficiaries? How do we need to get in touch with these parties? Essentially, just trying to get our hands around things, figure out what we're dealing with, what we're looking at there. It is a matter of taking a step back as well. Very oftentimes, when we're having this initial conversation, it, people tend to get very deep into the details very quickly. So we oftentimes encourage people to take a step back. Let's look at the big picture and assess what is truly necessary, what process is most appropriate. And again, that's a bit of what we're going to be focusing on as we start out here today. Again, what's the nature of the estate? And that's looking at how assets were held, how are they owned, and were they beneficiary designated? What was the individual's quote unquote estate? Not only just what was in their name, but what may have been in a trust, what was jointly owned with rights of survivorship. So again, looking at the full picture will dictate what path we take, how we advise from there. And then number three, one of the most common questions, of course, is as executor or as administrator, am I exposing myself to liability? And that is a very common concern, understandably so, of if I do take on this role, what obligation needing to fulfill, and am I putting myself at any risk? So it is something where you are not necessarily assuming the liabilities of the decedent, but you can get in hot water pretty quickly and expose yourself to some personal liability if you do things incorrectly. And I'll share a story in a little while when we're talking about creditors and all of that. But it is incredibly important to know the steps and to know the proper way of doing things. And so, again, that's what we're here for. That's what a lot of tonight's all about, of answering those questions. And again, we'll take it from there. But everything's so unique that we'll address this one by one. So we'll talk a little bit about our first hypothetical. Let's see. Kyle, do you want to run through this for us?
Yeah, absolutely. So I'm going to back up one slide. So one of the things that we were looking at when we have these frequently asked questions is, well, what's the nature of the estate's assets? And so one of the biggest things that we've got to figure out early on is what of a decedent's assets are going to be subject to probate. And so we've set up this hypothetical, and it's kind of like going to school, so I apologize if you feel like this is homework or something. But really, we've just kind of broken down what a typical estate might look like and listed some pretty basic information here. So the goal of this hypothetical, and we'll have a poll that goes along with this in just a minute, the goal of this is to determine whether certain assets are subject to probate. There are so many different ways to get here. The answer is probably not as clear cut as the way that this is laid out. Sometimes it's doing a lot of investigation, trying to figure out and get banks to actually talk to you to figure out if something is jointly owned, or if it was beneficiary designated, or if it was just in the name of the person who passed away. But bottom line here, we're just trying to show you kind of how we make a determination between what's a probate asset and what is a non-probate asset. So we've got a hypothetical. We've got James and Teresa. They're married with one child, Tommy. They have an estate consisting of some real estate that they own as a married couple. They have BB&T checking and savings account that they own jointly with rights of survivorship. There's a Capital One CD that's owned solely by James. We're going to assume when there's nothing listed there that there's no beneficiary designation on that. We have an IRA that's owned by James. Teresa is the primary beneficiary, and Tommy is the contingent. There's some life insurance, a vehicle, and there's a family farm way down or way out east in Belhaven. And so we're going to keep that up here. And then let's see, the first poll. Well, I guess the hypo goes away. But the first question that we have here is, James has passed away, and which of these assets are subject to probate? And so, not sure if you remember what the hypothetical might look like. Um, but if you want to venture a guess here, we'll kind of go through it.
Yeah, we can kind of walk through it together. So again, the GMC terrain that was owned jointly with no rights of survivorship. Um, the BB&T savings account that was owned jointly with rights. It did have rights of survivorship. Capital One CD was just owned solely by James. The 123 Main Street was owned as a married couple. It's called tenants by the entirety. And then, of course, the last option is A and C, the GMC and the Capital One. So we've got some answers coming in. Kyle, do you want to do the honors?
Yeah, so it looks like things are popping up here, and let's see. Looks like about half of you are saying the answer is the one at the very bottom, both A and C. And if you've selected that, you are correct. The GMC terrain and the Capital One CD are going to be the assets that are subject to probate. Saw a little message pop up, and I'll back up just a little bit. We've got our question is, what is probate? And probably something that we want to talk about when we're doing a probate discussion. So basically what probate is it's a court process for transferring assets. And so when an asset is subject to probate, that means that we need a court's involvement to actually get that asset to someone else. When something is not a probate asset, that means there's some other way to get it there. Typically a beneficiary designation, which is a contractual obligation that a bank or other financial institution has to pass that asset to another person. And then there's some other assets, like real estate, for example, which, spoiler alert, North Carolina does not treat a real estate asset that is in the state of North Carolina as a probate asset. It's got some probate-ish flavors to it, but it actually passes outside of probate unless somebody puts in their will that I'm leaving this to my estate. Executors, we'll talk about this a little bit later on. Executors have certain rights when it comes to real estate, but at a very high level, real estate is not considered a probate asset. And so back to the poll here, you'll see both A and C was our correct answer. The GMC terrain in this case is subject to probate because even though it was a jointly owned asset, it did not have a right of survivorship on it. Basically, when you apply for a vehicle title in the state of North Carolina, you have an option of taking it as tenants in common, basically, which is two people own it jointly, but there's no right of survivorship, or you can take it as joint tenants with the right of survivorship. If you're a married couple and you typically put your vehicles in both of your names, it's always our recommendation that you go ahead and have that joint tenants with the right of survivorship on it, because that contractually obligates the DMV to transfer that vehicle to the survivor of you. If it is jointly owned with no rights of survivorship, that GMC terrain, half of the value of that car is subject to at least some kind of probate proceeding. The other asset in this list that's subject to probate is the Capital One CD. Basically, when we were going through the hypothetical there, the savings account or the CD was not beneficiary designated, so it had nowhere to go without a court telling it where to go. So that means we're putting that asset through probate, at least some form of probate, depending on the size of that asset. But the other two assets that are up there, the savings account was, I believe we had that set as jointly with rights of survivorship, so it just passes to the surviving spouse in that case. And then 123 Main Street, owned as a married couple in this case, outside of probate, it just automatically transitions to the name of the surviving spouse. So the answer here, both A and C. So we had about 50% of you that got that one right.
I have a feeling we'll do better with this second one. So let's see here. Let me close that down. Again, as Kyle was just touching on, this is such a an odd area, but taking that step back, how is something owned? Was it beneficiary designated? That's going to dictate whether it goes by that beneficiary designation or whether it falls to that probate process. And we're going to touch on those phases, but again, you hear so much about probate avoidance and how to do that. Throughout this discussion, we're going to have some helpful tips and tricks on probate avoidance. Because you'll see the probate process, there's accountings, inventories, specific pieces of documentation we're going to need, and it can get complex pretty quickly. But let's take this second poll here. I'm going to throw this up here. So under this scenario, James has passed away. Which of these assets are not subject to probate? So again, kind of remembering what we were just going over. The IRA that was owned by James, Teresa is the primary beneficiary and Tommy is the contingent beneficiary. The BB&T checking account, that was owned jointly and did have the rights of survivorship. The family farm, that was Teresa is the essential insurer. I'm sorry, Teresa on the family farm, it's in her name only. D is all of the above. E-ish is none of the above. And hey, we've done much better on this one. Let me share these results with everybody here. Let's see. All right. So y'all can see we've done much better on that presentation there. So again, you've got it. Sounds like, again, with the IRA, Teresa was the primary beneficiary. That contractual obligation will control. The checking account had that right of survivorship. And this is something that is kind of an easy tip, a trick when you are doing that estate planning side of things. For those of you that are essentially trying to think of ways to make things easier for your executor, very often, again, not every single time, but very often we are encouraging people, hey, make sure those beneficiary designations are on those accounts. On bank accounts, they're called transfer on death, payable on death type designations. But making sure those designations are there, it's so much easier. It avoids that whole court process there. One last poll for you. Let me throw that up here. We'll kind of get to that. And here we go.
Yeah, on this one, so really quickly, and I think we might have given the answer away already, but basically in this hypothetical, Teresa has passed away. She had that family farm that was just in her name, way out in Belhaven, and the question is this going to have to go through probate?
It's kind of 50-50. We're not sure. Subject to probate. This could be kind of a trick question. It could be a little confusing. Is it subject to probate?
So it looks like about 10 of you say yes, 7 of you say no. I'm going to side with the 7 of you and say that it's not required to go through probate. Let's say that an executor, and this is forecasting some things that we'll talk about a little bit later on, but if an executor needed to sell that real estate, they can pull that back into the estate, and then all of a sudden it's subject to probate. It gets sold, and then we can pay off some creditors, and we'll talk a whole lot about that in a little bit. But for that asset to pass to someone, basically all we have to do is file a will, or if there is no will, it passes to Teresa's heirs at law in that case. So it's not subject to probate. There's still some estate filings that happen, but it does not need a court to transfer it. So correct answer there is no, not subject to probate, unless somebody makes it subject to probate.
We'll talk a little bit about that for sure. And we'll touch on that when we get to the application and inventory and all that good stuff. So next up, I do want to touch on the spousal allowance. Now, this is something, it's a really interesting tool. Again, if you're just going through this process for the first time, you may not be aware of it. And it's kind of a simplified way of dealing with a lot of administration issues. So we'll touch on this first and foremost. You do have the form with you. I'll kind of hold it up and see if you can see it. It's the one that says application and assignment of years allowance. And down in the bottom left corner, you've got little form numbers. It's AOC E100. And it kind of looks like that at the top, but it's application and assignment of years allowance. So pull that up for me. We're going to kind of walk through that together. But why this is so cool is essentially it allows a surviving spouse or certain children, and there's categories we're going to get to take the first bit of assets, the first bit of personal property, not real estate. So for a surviving spouse, it's the first $60,000. So very commonly, if there's just a vehicle or something like that, this is kind of an easy tool. You don't have to open a full administration. It's just getting things over to the spouse. So essentially, first $60,000 in value gets over to the surviving spouse free of creditors. And so again, it's pretty cool. If there's, say, credit card bills or something out there, you don't have to worry about any of that. If we're just dealing with a few little assets, sometimes it's a bank account or something like that, and the surviving spouse wants to take that free and clear of creditors, year's allowance all day long. Again, certain children can claim a year's allowance as well. And you'll see on that form, there's a little asterisk next to the surviving child. It's only $5,000 for a child or any children. But the child, again, few criteria. They either are under 18 years of age, and this also applies for someone that is in loco parentis, essentially kind of treat it like acting like they were their child, even though they weren't legally adopted. If the child is less than 22 and full-time student, that comes up pretty frequently. Unfortunately, we've dealt with that from time to time. If the child is under 21 and mentally incompetent, again, it's kind of interesting because you can protect certain pieces of assets prior to creditors. And we've dealt with this on several estates. So we'll kind of touch on that. And essentially, you put the items on here. You'll see on the second page, it's basically like a breakdown of what you're claiming. You give that to the clerk of court. Clerk of court signs off on it. If you haven't used your full $60,000, the clerk of court will show a deficiency of what you're still owed of that $60,000. But you'll take that year's allowance with the check to the bank or the title to the DMV of the car, get things traded over into your name, and it's a pretty clean process. Very nice tool that can kind of keep things, again, somewhat simple. So that's just an interesting tool, and we'll touch on that. But I have another little hypothetical to touch on with everyone. So in this hypothetical, Kathy and Jim are married. They own the following non-joint assets. So assets that are in their individual names. They've got the 456 South Street in Canton, North Carolina. I hope I'm doing that right. I feel like I may have butchered that. Kyle may need to correct me. That house is valued at $150,000. It's Kathy's rental property that she acquired prior to her marriage. It's just in her sole name. Jim has his 401k. It's valued at $800,000. Good job, Jim, on saving. Kathy is the beneficiary of that asset. Jim also has a 2015 Ford F-150. Good taste, Jim. That is just valued at $18,000. And then Kathy has her 2020 BMW X7 stylish. That is valued at $70,000. So again, we'll go through a little poll here, touching on this time. Let me throw this up here. So under this poll, Kathy has passed away. What assets can Jim claim under the spousal allowance? So again, just to run through these, the 456 South Street was Kathy's rental property. That's real estate. That's valued at $150,000. Kathy's BMW was valued at $70,000. That's the 2020, but that's solely in her name. Both or neither. Let me share results with everyone here. All right. So we've got a little bit of a mixed bag. So it's a tough question because of the value of Kathy's BMW, but you can claim a portion of that asset. Same thing if it was like a $70,000 bank account that's sitting in her name, you can claim a bit of that. So the correct answer is B, Kathy's BMW. The real estate, the South Street real estate is not able to be claimed on a spousal allowance. It's just personal property. So that is the vehicles, the bank accounts, investment accounts, things like that. Even some of the tangible household personal property, most often you're not needing to claim that, but if the conflict arises over who is proper owner, you can kind of try and claim some things there. So that's just something to be aware of. But again, it's capped at that $60,000 in value. The piece of the matter is, and just kind of an interesting side note, if Jim was acting and say he's the surviving spouse, but maybe Jim and Kathy were separated at the time of their passing, and Kathy had her plan updated. Jim could file a spousal allowance, even though he's not named under her will. He can still file that spousal allowance because if they're just separated and a divorce decree has not been entered, he's still entitled to this spousal allowance. There's other things he's entitled to at law, but this is oftentimes what comes into play. So we actually dealt with a matter like this, worked with one of our most favorite, lovely clients in a tough situation. She had been working on her brother's administration. She was named as executor under her brother's plan. Her brother had been separated from his spouse for a period of time. And that spouse, unbeknownst to our client, had claimed a spousal allowance. And she had started the process on her own and tried to manage things and was paying off creditors and taking care of things, and did not know that that spousal allowance was claimed. So they had just filed it with the clerk and said, hey, I have this $60,000 deficiency. It must be filed within the first year of someone's passing. That's why it's called a year allowance. So that was something she just didn't know was in the estate file. She had wrongly paid out to creditors, like credit cards and different things that were outstanding and claimed against the estate, when all of that money should have gone to the surviving spouse. And so that is something where the executor herself got into hot water. She had to, unfortunately, put money of her own back into the estate to rectify that issue. So again, when all of this comes into play, priority of claims and who gets paid out first, but this spousal allowance is tippy top. It is the one that gets paid first prior to everything else. So something just to be aware of and not get tripped up on there. Let's touch base. We've got one more poll on this, I believe. So let me run that. All right. And so this one says Jim has passed away now. We're just often people left and right here in these hypotheticals. Jim has passed away. Kathy's still living. What assets can Kathy claim under the spousal allowance? So Jim's 401k. And again, that was valued at $800,000, but Kathy was the beneficiary. Jim's Ford F-150. That was solely in his name, valued at $18,000, both or neither. So I'll give you a second. We've got some coming in there. And just in the interest of time, I'm going to go ahead and touch on this. It would be Jim's Ford F-150 because this 401k had the spousal or the beneficiary designation. So she wouldn't have to take it under the spousal allowance because she was already getting it from the beneficiary designation. The other piece, the last piece I want to touch on real quickly with the spousal allowance, again, the big benefit is you're taking those assets free of creditors. But prioritizing how we eat up that 60,000 is also an important item to be aware of because certain assets are naturally creditor protected. Depending on who is the beneficiary, say a life insurance policy, if you're giving it to a spouse or a child in North Carolina, that's a naturally creditor protected type asset. Certain retirement accounts are naturally creditor protected. So strategizing on how you're actually utilizing that 60,000 is incredibly, incredibly important. Again, we're happy to walk through that together. But that's a little bit about spousal allowances, a very kind of interesting, cool tool there. Kyle's going to tell us a little more on limited personal representatives.
Yeah, so basically, just to kind of reset, what we're talking about are some short form administrations where you don't have to go through a full estate administration and that 6, 9, 12-month process that takes up a lot of time. So these are our short form administrations. What Lauren's touched on so far is the spousal allowance, which is going to cover basically it's a way to deal with personal property. This one is called a limited personal representative. What we're doing here, so what is it? First of all, it is basically you apply to the court to be appointed for the limited purpose of running a notice to creditors. So when is this really appropriate? Most of the time, we're dealing with real estate when we're dealing with this side of things. So you're applying to the court so that you are the limited personal representative. You are appointed for the sole purpose of running a notice to creditors so that you can administer any claims. Why is this important? The biggest reason is in North Carolina. One of the questions that I see on a couple of these on the attendee chat here is dealing with real estate and probate and how those things interplay. Probate in North Carolina does pass outside, or real estate in North Carolina does pass outside of probate. But before somebody can sell that real estate, basically we need to verify that there's no creditors that may claim against it at some point. So if an estate only consists of real estate and that real estate doesn't really need to be sold right away, we can basically file for a limited personal representative. They can run a notice to creditors. That's going to satisfy a title insurance company and a closing attorney later on that, okay, yeah, we double checked. There was no outstanding creditors at the time this person passed away. That asset, that real estate did not need to be pulled back into the estate. So basically, again, just doing this to run a notice to creditors, mostly when we're dealing with real estate. Lauren gave a story earlier. I'll give my story here. The limited personal representative, I personally like to use these very sparingly when it's appropriate. It's a great tool. But not all that long ago, we had a client who basically she was inheriting real estate. There was really nothing else in her mother's estate. Everything else had been a non-probate asset. She got it through beneficiary designation. So real estate was the only thing that we needed to do some kind of a filing for. So she said, well, I don't need to sell it. I'm going to hold on to it. Maybe I'm going to rent it and make some money that way. So we did the LPR, and all of a sudden she gets an offer on that property that she just can't refuse. It's, a market was hot, and you know that it's been hot recently in this area. And all of a sudden, this LPR isn't going to do what we want it to. Basically, in order to sell real estate within 2 years after somebody's passed away, that notice to creditors has to run. But if you're trying to do it sooner rather than later, it's usually our recommendation that we go ahead and open a full estate so that the executor can join in that sale. All that put together means that real estate passes outside of probate, but sometimes we still need the executor to sign off on things and say there's no creditors that are going to be coming forward to try and take this back later on.
It's so quirky because it is one of those things of it automatically vests in the beneficiaries. It's their property as of the date of passing of the owner, but it's always a little more complicated than that. Creditors can institute proceedings to pull it back into the estate and lay claim, try and foreclose on that property. So as Kyle's touching on, it's more of a title searching piece that if we want to sell within 2 years after someone's passing, we want to make sure this notice to creditors is run. And this is kind of one of those helpful tips and tricks. This is also a reason that we see some people putting a trust in place. And it's just something to evaluate whether it's appropriate for you. But some individuals have had very bad experiences, understandably so, with probate, going through it for a loved one or what have you. They want to avoid probate as much as possible, and any little dealings with the clerk of court, even as little as limited personal representative. They put a trust in place, deed their property into the trust. Once it's been there for over 2 years, you don't have to deal with any of this. At your passing, the trustee just deeds things over, and it's very clean. But yeah, it's kind of an interesting piece. It's one of those things of you don't necessarily have to open a full estate. This tinier option is a good option for a lot of people. Excellent.
Yeah.
You want to touch on small estates?
Absolutely. So this next one is called another short form administration. The last one we were talking about was the limited personal representative, and that is going to deal with real estate. Back to the personal property side of things, though. This is a lot of people will call this a small estate. The form that you may have, it's called a collection by affidavit. Um, this is really for and it's called a small estate for a reason, but for people who don't have a lot in probate assets, doesn't mean their estate itself, the larger estate wasn't big, but their assets that are subject to probate fall below some statutory level. Um, right now, someone can use a collection by affidavit or a small estate proceeding if the value of assets going through probate is less than $30,000 if you are a surviving spouse, or if it's less than $20,000 and you're anyone but a surviving spouse. So this is only going to work for personal property. Real estate requires some other. We can do this in conjunction with the LPR, the limited personal representative, or we don't file anything at all if we know someone's not going to sell it and it's going to vest and we're not worried about it. But this collection by affidavit, we use it to transfer personal property. Basically, how this works is you file your affidavit or file to be appointed as a collector. You're appointed by a court, and it kind of works the same way that a full administration would, but you're not the executor at this point. You're what's called a collector. And so you basically can marshal the assets, the probate assets together. They are subject to the claims of creditors. So that collector is responsible for paying any debts, and then the money gets distributed according to the decedent's last will and testament. So the biggest issue, and a couple tips here that we see with this collection by affidavit, is sometimes somebody's passed away. They have an estate that might be worth, I don't know, call it $18,000 of probate assets. It was not a surviving spouse type situation. So there's only $2,000 left to kind of play with before you bump up into what we consider the full estate territory. We have to be really careful here when it's that close. The $2,000 can get eaten up pretty quickly if something like a tax refund comes in, or if refunds from insurance come in, or if there's just an unexpected asset. You can switch gears and do a full estate at any point, but it behooves us to go ahead and make sure we've done our investigation on the front end,
Yep.
that we're really close to that. If we're really close to that $20,000 number, it's usually better just to go ahead and do the full estate so that we don't get caught with any surprises.
Yep.
Probably one of the bigger Advantages of this, though, is a small estate, the closing affidavit. This one has to get knocked out within 90 days of starting the process. So we're talking about 3 months instead of a minimum right now in Wake County of probably more like a year when we're dealing with a full estate. If we're being optimistic, maybe 9 months, but for the most part,
In these COVID times.
yeah, we haven't really seen the full brunt of COVID on the courts yet. It might be more than a year for even simpler estates.
Yeah.
This 90-day process is a lot nicer.
Yeah, for sure, for sure. And it is one of those things of, yeah, if we're on the borderline, we may just do the full admin. I think you touched on the notice to creditors is not technically required with this, but if you're doing a small estate and looking at filing an LPR to run a notice to creditors, might as well just do a big estate and do it all under one. So again, knowing the options, knowing the tools in the toolbox and which one makes the most sense for you. But those are kind of, believe it or not, the simpler of the options. We're going to touch base on what is a full administration, what is true probate look like. And again, just high level on this. I know we're kind of coming up on 45 minutes here. So I do want to touch base and pause on some of the questions on those simpler versions before we shift to the higher versions. I saw a few come in that I can just answer real quick here. There was a question, can you take a spousal allowance on an asset that has been beneficiary designated to somebody else? Good question. I like the way your brain's thinking, but no. This is just talking about assets that were not beneficiary designated, not jointly owned with rights of survivorship with somebody else. But interesting theory. It's just those quote unquote assets that are subject to probate, the tangible personal property, the other intangible personal property. Real property in another state, does that add complications? You betcha. So as we were talking about in North Carolina, it's actually one of the nice simple things where it automatically real estate, the home vests in the beneficiary as of the date of passing. That's not the way it is in every state. So if you have real property in another state, that is something we can talk about. But if you haven't done any planning, that necessitates a whole ancillary administration in that other state. We have to associate with counsel in that state and get them to help with transferring the property and making sure it's proper on the real estate records in that state, because every state is different. Of course, we can't have like common uniform ways of doing this. From a planning perspective, and again, tips and tricks on how to avoid probate, most often when we're working with clients that maybe have a condo in Myrtle Beach or something we had one in Colorado, owned a mountain property, a trust is a good option at that point. Deed it into the trust, take care of it now, and then at your passing, the trust is still living, and you can essentially just deed it out of the trust according to those terms. So those were a few of the quick questions there, but we'll keep on going, keep on chugging along. A full estate admin is quite a process. Again, taking a step back of when is it available, when is it appropriate? None of those short forms that we talked about really make sense. Who is acting? Do we have a will? Do we not have a will? There's kind of two terms that mean essentially the same thing. Executor is the person that controls under a last will and testament. If there was a will, they name an executor to run this process with the clerk of court. If you don't have a will, if someone passes away intestate without a will, it's an administrator is the personal representative of the estate to run the process. So kind of interesting, different terminologies. We are going to touch on, let's see here. Let me advance our slide. We're going to sit here for a second and pull out some of our handouts. If you want to pull up, there is the application for probate and letters. That is AOC E201. I'm going to just kind of walk through this very high level, but again, application for probate and letters. That is when you have a will. So that is, again, probate and letters. Testamentary is what you would check on that when there is a will. If you don't have a will, it's application for letters of administration. But what that is essentially we're going through this process. God forbid someone has passed away. You've been named as executor under their plan. I'm going to talk a little bit about the opening phase. And again, this is you file this application, which we're going to look at. You file a form, a little oath saying, I will do according to the laws of North Carolina and not be naughty and do anything I'm not supposed to. You file the original last will and testament, and I'll touch more on that in a minute, but keeping track of those original wills, and then an original death certificate as well. So application, oath, original will, death certificate. Those are kind of the key pieces of opening up an estate. Essentially, one of the things to be aware of is theoretically you can potentially try to probate a copy of a will. It is a more involved process. You have to petition the court for approval and get the court's approval to do so. So to avoid all of that, keep track of originals. Again, I'll touch base high level on this application and just a few pieces to be aware of. But you're going through filling out the information of the decedent, the individual that has passed away. You're filling out your information, the information of the applicant, the person that is trying to become executor or administrator. And again, if you have counsel, you're putting that attorney's information under there. But this is touching on some of the requirements at law. And again, you're certifying that under the will that I've given you, I'm named as executor. If you're not named as executor, there are still certain situations where someone else can step in and serve in that capacity. So essentially, if all others, the individuals named in the will have renounced, they can name someone else to serve in that position. That's what they're talking about there. And there's also something called implied renunciation. And so this has come up frankly, just one time for a client of mine where there was a public guardian serving, which was the court-appointed guardian. Individual passed away. Family did not jump on things right away, understandably so. They were grieving the loss of their loved one. And so after 30 days of not applying to serve in this role, the court deemed that they had impliedly renounced and appointed someone else. That public administrator became public executor, or the public guardian became public executor. So again, interesting piece of information. If there's conflict, you do want to act quickly on this. But breaking things down, a common question as well is, what if I've got an ex-spouse or someone named under my plan? Certainly, we want to update that. But if, God forbid, someone were to pass away and a divorce decree has been entered, that's the key. If it's just separated, nothing changes. But if a divorce decree has been entered, it's treated like that ex predeceased the individual. So they won't serve as executor. They won't get anything under your will. You do want to review beneficiary designations. We've seen that a few times of they don't get anything from the probate estate administration. But if they were a beneficiary designation, it's most likely that they're going to get that unless there's a big challenge and unlikely. The second page of this document I want to touch on high level, and that will lead me into our inventory phase. You'll see at the top of this form, it says preliminary inventory. So it makes sense if you take a step back, but at this point, you're just applying to be the executor or the administrator. You don't have any real power at this point. So this is just kind of a best good faith effort on what we're looking at. Part one of the property of the estate is assets that were solely in the name of the decedent that are subject to those creditors. So you'll see, again, accounts, bank accounts, sole name of decedent, Joint accounts without rights of survivorship, you're accounting for their percentage. So say there's a bank account. This happens sometimes, even with spouses. If there's a bank account and it doesn't have that right of survivorship, 50% will fall to this process here. Stocks, bonds, mutual funds in the sole name without beneficiary designation. The other piece I want to touch on here, household furnishings. You don't need to go through and do a detailed inventory of every piece that's in the house. A general figure is fine, unless kind of two situations, we anticipate conflicts, then we get very, very detailed with it very quickly. Or two, if there's specific devises, specific gifts under a will that says, I want this grandchild to have this sewing machine. And in my family, a lot of you have heard me share this. It's a clock that doesn't keep time. It's going to my eldest brother. We're going to have to line item that out. But otherwise, just group things together. And you are also getting charged court fees on the values, the estimated market values. So we tend to keep things at yard sale pricing. Sentimental, that clock is priceless to us. But on this inventory, maybe 20 bucks, maybe. I don't know what someone would pay for it at a yard sale, but again, just trying to keep court fees low. No need to inflate those values there. So that's part one, sole assets in their name. Part two, you'll see is property which can be added to the estate if needed to pay claims. And so this is joint accounts that had that right of survivorship. Those bank accounts, you still have to list them here. Stocks, bonds that had that transfer on death designation or a designation right of survivorship. And you'll see real estate owned by decedent not listed elsewhere that may have had that right of survivorship. Or it's really dealing with real estate that was solely in the name of the decedent. Those are assets, again, if there's insufficient assets on part one, say there's only really a bank account sitting there, they may, if there's a big creditor out there, try and pull that real estate, the house that was solely in the individual's name, back into the estate to liquidate and get their money. So that's why you have to disclose that on that part two. Again, at the phase of opening, we may not know all those values just yet. I'll touch on that on the inventory. But part three is just other property, disclosing to the court, was their entireties real estate owned by husband and wife? That's what that means. Just disclosing yay or nay. Was there IRAs, annuities, retirement plans like that had beneficiaries? Most often, yes. And is there a potential claim for wrongful death? And again, if we're ever thinking maybe, just click yes. That's a high level of the opening application, which again kind of leads right into the inventory. It's very, very similar. I'm not going to take up too much time on this inventory piece, but this inventory is Form AOC E505, and you can actually pull up any of these documents online. So if you just Google AOC, North Carolina AOC forms, you'll be able to file and see, well, you'll be able to find and see all these forms online. But it just says inventory for decedent's estate at the top there. It's going to look very similar to that second page of your application. Part one is all of the assets that are quote unquote subject to probate. As we were touching on in the beginning of this seminar, what was solely owned, not beneficiary designated, not having rights to survivorship. This is what you get your court fees on. Again, you'll get charged at the application phase. If it goes up at the inventory phase, you're charged again. But it's $4 on every $1,000 that goes through probate. So while we don't have estate and gift tax in North Carolina, they do take their piece through this probate process. It's maxed out at $6,000, but you can tick up pretty quickly if we've got significant assets going through here. Again, part two is just those assets that can be added back in. The main thing to be aware of for the inventory, one, is that you have your opening phase. When you've been appointed, you get your letters of testamentary if you have a will. to appoint you as the executor, letters of testamentary. Under an intestate administration without a will, it's letters of administration and appoints you as the administrator. But that's kind of your keys to the kingdom. That means you can talk to the bank that hasn't been talking to you, and you say, I've been appointed by the court, give me all this information. But you have 90 days from the date of getting those letters, the date of your appointment, to file this inventory, to get ready, get it finalized, get it submitted. It sounds pretty simple, but when you're dealing with financial institutions and trying to gather all this information, 90 days goes by really quickly. So being proactive with it, that's something we talk a lot with clients about. A tip, a trick about a smooth administration for yourself. Have a cheat sheet of where are assets. Clients that are on this call, you've heard this time and time again. We love the cheat sheets. Where are assets? Are they beneficiary designated? Who's it going to? That way, if someone needs to step in, they're not trying to figure out, where did someone bank? Did they have a life insurance policy? I kind of remember they had a life insurance policy, but I don't know where. Have a cheat sheet. It's so much easier for your loved ones to be able to help out. There are ways of searching. If you don't have it, you can send out letters to institutions. But as you can probably guess, many institutions don't respond right away. And so, again, just having that information at someone's disposal is the best course of action. Those are really the high points of the inventory. Last piece is, again, the preliminary inventory was just a best guess. This is, you've got your letters. It needs to be a to the penny value of what the individual, the decedent, had in their name as of the date of their passing. So this is kind of a snapshot of everything as of the date of the individual's passing. And every piece that you put on here, every statement you make, you have to have documentation for. So bank statements that you highlight, here was the value of this account as of the date of passing. Investment account statements of, on this day, here was the median value of this investment account, or what have you. We walk clients through that all the time. I'm going to be quiet for a moment. Let Mr. Kyle Frizzell tell us about accounting and all the fun that is involved with that.
Yeah, thanks. So in case you can't tell, there is some huge benefit to making sure things are beneficiary designated and kept outside of probate. As Lauren said, that inventory phase is a to the penny snapshot of what the decedent had in their name as of the date of passing. Once that inventory is filed and approved, though, I don't want to say things necessarily get simpler, but it is our goal to simplify the process from there. We move into the accounting phase, and you'll see some of the things on the slide there about consolidation. It says consolidating documents. It also should say consolidating assets and accounts. So one of the things that we're doing in this process, you may have heard of it before. Most often we're setting up what's called an estate bank account, which is where we take these assets that were in the decedent's sole individual name and we put them in one place. By doing that, we're consolidating the accounts. We are showing an actual value of the estate, and that pot of money is what we're going to use to pay off any creditors that come forward during the notice to creditors period. We're also going to, this is ultimately, if there's money left over, that's the money that gets distributed according to the terms of the will or according to intestacy, which is you passed away without a will. The law is going to tell us where those assets go. So our overall goal during the accounting process is to simplify things and ultimately distribute things out and close everything down. But there's some things that are going on at the beginning of this process, and often one thing that Lauren was touching on was the notice to creditors period. We often will start that as soon as we can once you're appointed, so that those clocks start running. Creditors in North Carolina get the, basically they have 3 months from the initial notice period to file a claim against the estate. If you know about a creditor beforehand, they're known, you have to pay them. But if they're an unknown creditor, it's something that you just can't ascertain on your own. That's the purpose of that notice to creditors that you see in the newspaper. Tells everybody where to file their claims, what estate file to put it in. Once all that's done, there's going to be a list of claims against the estate, either known or unknown. And that's one of the things that during this accounting phase that you're going to work towards. You're going to have this list. There is a certain priority that you pay these creditors off in. Lauren's going to touch on that a little bit more later, so I'll save that fun for a little bit down the road. But just suffice it to know at this point that you need to be basically, we don't want to take any money out of that estate bank account until we know the right order to pay people in.
Yep.
We want to pay the class 1 creditors first, and we want to pay, I think it's what goes through class 9.
Yeah.
We'll pay our 9th class creditors last, and then whatever's left over is what winds up going to the beneficiaries. One of the other things you'll see on the list here in the accounting phase is paying out of pocket versus reimbursement. What we're referring to there are court filing fees, any attorney's fees during that period, basically the cost of the administration. A lot of times this depends on the nature of the assets. If it's a pretty liquid estate, there's a lot of cash, there's really not a reason not to pay from the estate account. But if it's an illiquid estate and we still have bills that need to be paid, most of the time the executor can pay these things out of pocket and seek reimbursement from the estate. I raise that just because that comes up a lot, especially when we've got bills that need to be paid, but there's assets that we're still waiting for them to be sold. Another one of the big items that happens during this accounting phase, again, during this accounting phase, we're trying to pay off creditors, we're trying to see what's left, and we're trying to get the money out of the estate. Taxes are probably one of the biggest things that we need to touch on. I've got a slide about that later on, so I'll save the minutia of it. But we need to know what the decedent's last tax burden, if there is one, is going to be so that we can pay North Carolina or federal taxes at the right time. So there's a whole lot of moving pieces during this accounting phase. You should have an accounting form in your packet. I won't walk through that line by line. But basically what we're doing with that accounting is if there's assets that come into the estate, you're going to report that as a receipt of the estate. If there are monies that are being expended on behalf of the state, that's going to be a disbursement. That's paying bills and paying creditors. And then ultimately, if money is coming out to the beneficiaries, that's going to be a distribution. So that kind of leads into the closing down part of this process. Basically, if I'm trying to oversimplify this and in the essence of time, what we want to do is just keep all the paperwork. Make sure you have receipts for every bill you're paying. Make sure you have releases from creditors so that we know that or we can show the clerk of court that those were paid. And then we want to have copies of check images for final distributions that are coming out of the estate. That's a very 50,000-foot view of what's happening during the accounting and the closing phase. And of course, if you have specific questions, we can address those in one of those one-on-one consultations. From this part of the process, things can go in so many different directions. Bottom line, making sure we're trying to close it down and get money out of the estate.
I feel like, and Kyle, you certainly may be able to add to this, but I feel like it's the accounting phase is where individuals tend to get overwhelmed. And so they may be DIYing it and get through the inventory phase and just not be able to make it through the accounting phase because the clerk is so particular on the type of documentation they want to see. And you could go to one clerk and they say, all right, you need to fix XYZ and bring me this piece of documentation. If you go to a different clerk, you might get told a different story of what they want to see. And every penny has to be traced. So you have to account for everything that comes in and that goes out of that estate. And as Kyle is touching on, keeping those records. It seems a little odd to start writing checks for everything because no one seems to write checks nowadays. I'm still kind of a little nostalgic. I still remember writing checks at the grocery store, but it helps in the estate administration context where if you can show a canceled check image from the estate bank account for something, that is a good piece of evidence the clerk wants to see of money that actually went out. So again, as Kyle touched on, there's so many twists and turns an accounting can take, but we're happy to touch base with you if you have individual questions. Again, in that attendee chat, I hope you're not getting overwhelmed with all this. Let us know if you want to have one of those one-on-one consultations with us. We can run through it. But Kyle, do you want to touch on some of those fun tax considerations? Because taxes work their way into everything for sure.
Yeah, absolutely. So one other thing to add on the accounting phase, basically what we're aiming for on the accounting is we want to file a final account. And when a final account is approved, that closes the estate. There's also something called an annual account or an annual accounting. That means that we were not able to finish everything within 1 year from the date of qualification. And that's okay, not a problem, but we still have to, every year on that date, provide some sort of accounting to the clerk of court to show that you're still doing your job. So happy to touch a little bit more on that in one of those one-on-one consultations. But to keep things moving a little bit, the taxes piece of this, I don't want to understate it. This is a big deal. But most of the time, I'm not a tax guy. I know enough to say you should probably talk to a CPA about all of this. But it's our part of our process during this accounting phase, or maybe even earlier, to start preparing the decedent's final personal income tax return. So there's a couple tax returns that we're worried about there. The final personal income tax return is usually the one that we're dealing with the most. North Carolina doesn't have an estate tax, so you're not getting taxed on the value of your assets at passing. The federal government does, but it's so high right now at roughly $11.5 million, give or take. If your estate is worth less than $11.5 million, we're not filing an estate tax return. And again, those numbers are a little bit more exact. And the only other one that comes up sometimes is there may be an estate income tax return, but that's only if the estate generates income after passing. So these are all things that you should address with a CPA. The reason for that is there is a priority to these, and they have to be paid in order as part of that payment of claims against the estate. So again, can't understate the importance of making sure taxes are paid. If refunds are due, that's an estate asset and it has to be accounted for and distributed according to the will. If a tax is due, we have to work with the IRS to make sure that it's paid timely. Or if we need extensions, we do that the same way we would for a personal income tax return. But I think those are my highlights there. Lauren, I don't know if you have anything to add on the tax piece.
Yeah, no, you're exactly right. Everything with taxes cannot be skimmed over. One thing to add, a common scenario that comes up is decedent hasn't paid taxes for many, many years, and I'm not sure what's owed. That is something to tackle head on. It can be overwhelming, and we totally understand that. We connect those clients with good CPAs that can do that back work, because again, you cannot and you don't want to start distributing things out of the estate if there's the IRS is sitting there and saying, oh, that money actually belonged to me. So incredibly important. And that kind of leads into the creditors discussion. Again, these are some of the most common creditors. I'm just going to touch on this high level, but similar to taxes, as I'm kind of touching on this high level, it is incredibly important. So making sure in your particular facts and circumstances, you're doing things by the correct priority. Remember the story that I told at the beginning of the seminar of the sister that started paying out to creditors prior to paying the spousal allowance, and she had to pay back into the estate because it wasn't correct. So spousal allowance comes first, then claims against that the government has a lien on a property. So you can kind of pull real estate records and see that. Second class is funeral expenses with a 3,500 cap. That's not including burial place or gravestone. Third class is gravestones at 1,500 cap. Fourth class creditor is taxes under federal law. Fifth class is North Carolina. Sixth is judgments. Sixth class creditors is where Medicaid comes in. So if a loved one was receiving benefits through Medicaid, this is where they come in and try and recoup their cost. So they're a sixth class creditor. But again, just to be aware, administrative expenses also, it goes spousal allowance, administrative expenses, all these other creditors. So if the executor is paying court fees or a CPA fee or potentially some attorney's fees with the approval of the clerk, those can come out as administrative expenses off the top before creditors get paid. But again, that's something to be very careful when you're talking about the priority of what goes where and how things get paid out. So primarily just something to be very clear on, be very careful with there. But we'll touch on this last little hypothetical that we're going to run through. Kyle, do you want to walk us through this one?
Yeah, absolutely. So, don't want to spend too much time on it. We just want to make sure that we're hitting and putting some of these things together for you. So, what this is dealing with a full estate administration, pretty simple facts here. One thing I do want to distinguish before we do this is we've talked a lot about the probate estate, and then we've also got this number here. So it says Clarence and Judy are married. They have an estate worth $2 million. You can have a really large estate and then have a very small probate estate. So just want to make sure that we're clear that there is a distinction there. But so Clarence and Judy have an estate worth $2 million. Let's just assume, and it's not written here, but this $200,000 worth of stock that's owned solely by Clarence is our only probate asset. Clarence passes away. Judy's named as the executrix or the personal representative, however you want to refer to her. So we have this first little poll here. The question is,
still awake? Is everybody still with us?
So we need to know if she needs to open an estate. It looks like votes are coming in, and so far, I agree with you. The stock is not beneficiary designated. It is well more than the spousal allowance. It is well more than the small estate will allow us to deal with, and that limited personal representative isn't going to do anything for those stocks. So the only thing that's left is that full estate administration. You have to open a full estate to move that stock over to Judy or whoever the intended beneficiary is.
Mm-hmm. All right, this next one, let me pull it up. Is a spousal allowance available to her? So again, kind of harkening back, there's $200,000 of stock that's owned to Clarence, or owned solely by Clarence that did not get beneficiary designated to Judy. Is a spousal allowance available to her? Yes, you guys are rocking this. You got it. Yes, it's available to her. But why we wanted to touch on this again is whether or not it's appropriate. If there's $200,000 of stock sitting there, and we're only protecting the first 60K, most likely if there's a credit card or a medical bill or something like that, they're just going to get paid out of the next 10,000 or what have you that's sitting there. So in this situation, most likely doesn't really make sense to file a spousal allowance because they're just going to get paid one way or another. So just settle it and take care of things. Again, just high level looking at what's appropriate there. Trying to keep things simple and not overcomplicating it. Let me run this one for you, dear sir.
Yeah. So this one just kind of a comprehension-based question. So after Judy qualifies as the executrix, how long does she have to file the inventory of the estate? So she went through that opening phase. We need to know how long before she needs to file the full inventory with all to the penny value of the probate estate.
All right.
All right. Yep. And the 88% of you there are correct.
Way to go.
The 90-day inventory. But if you can file it within 30 days, great. Let's go ahead and do it.
Yeah. Love it. Love it. Love it. Last but not least, let's see here. So Judy is unable to complete that stock transfer within 1 year. Hopefully this would never happen, but if she drug her feet for a little while, let it sit there and just couldn't get to it for whatever reason, life happens. What would she need to file to satisfy the clerk? So spousal allowance, motion for extension, annual account, final account. Let me share y'all's results. So kind of mixed bag here, but the correct answer is annual account. Again, as Kyle was touching on, if you go over a year from the date of your qualification, you have to file that annual account to keep in good standing with the clerk. But say you're at 11 months and just don't have enough time, and you know you're not even going to be able to file the annual account, you can file a motion for extension, but you'll still have to file that annual account and then a final account for whatever little bit is left there. So motion for an extension is a good tool in the toolbox to be aware of, but you still have to get that annual done.
I think we like to do both. I
Yeah.
think if we're doing kind of a best practices there, we want to get the extension so that we've got a new calendar for filing the final, but we also have satisfied the clerk that, hey, we're still working on it. Here's this annual account for you to take a look at.
Oh, yes. Always keeping in the clerk's good graces, for sure, for sure. So as we're wrapping up here again, appreciate all of y'all taking your time with us this evening. It is one of those things where there's so much to every little bit of this, and we're just touching on things high level. But send in your questions in the attendee chat. I appreciate we've gotten a lot of questions there, and we'll touch on those in a moment. But to touch on some of the tips and tricks of a smooth administration, of trying to touch on this along the way, but again, just avoiding in some of engaging in some of those probate avoidance tactics. So having beneficiary designations, as we've touched on, incredibly important. If you don't want something going to someone outright, looking at a trust. That's the other probate avoidance tool. There are some firms out there that just put everybody in a trust. While we draft trust all day, every day for clients, it's not always necessary. Sometimes you can do it with a will and beneficiary designation. So looking at what's the best option for you and not just charging you for a big fancy trust plan when you don't need it. Communicate where assets are located. Again, that cheat sheet is critical. And then communicating on wishes is the other thing. So we kind of glanced over it, but the tangible household items, those sentimental pieces, if you have strong wishes or if you've told someone they're getting a certain piece, communicate that to everybody and have it in your plan. So being proactive on those communications. We had an estate where son was told he was always going to get this taxidermied fish. Yes, they were fighting over a taxidermied fish. And we spent a lot of time and a lot of money on this, unfortunately. Surviving spouse also had fond memories fishing with her husband. Of course, she was second spouse, so it was stepson, stepmother. Yes, communicate being the key on where things are, who gets what, and then engaging in some of those proactive planning tools. Kyle, do you want to touch on some of the during process fun tips and tricks?
Yeah, absolutely. So to add to the proactive piece about it too, one of the things that I always like to say is if you update your estate plan, don't hesitate to destroy old copies of the will. It sounds crazy, and you probably paid a lot of money for that first estate plan, but we want to avoid any confusion. So one of our proactive tips is just don't have a whole bunch of wills laying around. It gets a little confusing. During the administration process itself, I think one of the biggest things that we can say is start early. So I know, undoubtedly this is one of the toughest times that people deal with after somebody's passed away. And you don't want to dive right in to administering the estate. Some people do. People grieve differently. But the start early piece of this, if you're going to try and take an active role in this, start marshaling the assets, trying to figure out where things are as quick as you can, or know that there's people like us out there that can help. And if this isn't something that you feel capable of doing at the time, we're here for that. That's part of our role, and we can take an active role in marshaling these assets. But if it's you, if you're the one that's doing the process, going through the estate administration, the other thing to be well aware of during the process is making sure you're aware of the deadlines. Probably one of the worst things that we see is people get appointed. That triggers all the deadlines for the next year. So once they're appointed as the administrator or the executor, we've got this timeline that we need to work with. And it's amazing what putting it on your calendar will do. Um, so
Yeah.
making sure you're staying on top of the 90-day inventory, the 3-month notice to creditors period, what the 1-year anniversary of your qualification is so that we get that annual account in, and just staying on top of it, trying not to, it sounds simple, but you don't want to fall behind. And it's pretty easy to do, unfortunately, because you still have a life to get to. You're still going to work, or other things happen. Um, a couple other points here. Just make sure you're communicating with the beneficiaries. So if it's not a surviving spouse as the executrix or executor and who's receiving everything, just let the beneficiaries know that this is a process. We want to let them know that, hey, you're a beneficiary. There's going to be something in this estate for you, but we've got to go through this process, pay off creditors. And it's amazing the tension that relieves, because I can't tell you how many times that conversation doesn't happen and our phone rings and we get questions like, well, when is this money coming? I was told I was supposed to get $20,000 or something like that.
Mm-hmm.
We just,
Mm-hmm.
hey, um, we understand that. We know that once you hear that number, you think it's coming. But just being upfront about the process and knowing that we're getting through it as efficiently as we can. Making sure that you are doing proper searches for creditors is another thing to be aware of during this process. Making sure there's no outstanding liens on real property, whatever it might be. And then my last one that comes along with a little bit of a backstory, but I won't share all that with you. Lauren said earlier to use checks throughout this process. The bank is going to offer you a debit card for that estate account. And if you go to the same bank that you bank personally with and get a debit card for the estate, you will be tempted to go to Taco Bell and you will have to put that money back into the estate. I've unfortunately had that happen a few too many times. Some car parts, Taco Bell, KFC.
It is not your credit card.
That's right. Fancy dinners, don't put that on the estate account. Make sure you're using checks for those things.
No. Yeah, yeah. And again, we really appreciate y'all taking the time. I hope this was helpful. We really appreciate your chats and the feedback and your kind words. If you're able to stick with us, we are going to address some of those questions. If you need to hop off, I do just want to let you know we do have a recording of this that will post to our YouTube page, and we'll be sending out follow-ups to everyone. So essentially, you can let us know if you have any questions. Again, for attendees of this event only, normally consults with us on this stuff is like $350, but if you've attended today, let us know if you want to sit down and have an individual just sit down discussion via video conference nowadays, because we're still social distancing, and we're happy to chat. But I'm going to kind of bring up some of these questions and just kind of take them piece by piece. We'll probably take another 10 minutes here if you want to stick with us. If you have to hop off and get some dinner or get back to the day-to-day, let us know. That's fine. But let's kind of take this first question here. And again, really some great questions. And I'll pull up this first one here. What if you need an original will? It's filed in two courts in two different counties. So what I think this is getting at, essentially in North Carolina, if you're domiciled somewhere, that is where the kind of what they call the domiciliary, the primary estate, if you want to think of it like that, is supposed to be governed. So the county in which you reside at the time of your passing is the domiciliary administration county, the proper jurisdiction for the primary administration. But say you own some beach property down at Wrightsville Beach, and you want your attorney to come visit you. No, just kidding. But you own some property down in New Hanover County there. You have to file the original will in Wake County here. And then you get what's called certified probate papers. It's essentially a fancy version of a stamped version of it by the clerk, certified. Mail those down to New Hanover County, get it on public record down there, and that serves as the title searching piece in New Hanover County. So you can really, there's only one original will, file it in the domiciliary county, and then if you need to file copies, certified copies in North Carolina, exemplified copies if you're doing something in another state like we talked about. That's just stamped twice and extra fancy. But again, if you're dealing with multiple counties, give us a call. Happy to touch base there. All right, let's see about another question here. We'll maybe run through this together. Is an executor within the rights to use CPA or law firm services during this process with fees paid from the estate, or does the estate or will need to allow for the expense? Kyle, do you want to touch on that of the proper times of when a CPA can be reimbursed and when an attorney can be reimbursed?
Yeah, so the second part of that question is kind of the key part. The estate or the will should allow for the expense, but if there's nothing expressed in the will, there's some statutory powers that do allow for this. Kind of depends on how the will's drafted. If the will says they have to pay for it themselves, there's probably not a whole lot we can do, but I've never personally run into that. But if a CPA is filing tax returns for the estate or for the decedent's final personal income tax return, those can be considered cost of administration. The estate can pay for those. What often happens is that becomes one of those reimbursable expenses. Maybe the executor goes ahead and pays for it in the interest of time. And then the estate, once we get to that accounting phase, can look at that receipt and reimburse the executor for that. Same thing for a law firm. If the law firm is doing services on behalf of the estate, we do have to what's called petition for counsel's fees. So the court, all of this is subject to court approval, and that's true for the CPA fees as well. The estate can pay for them, but there has to be enough assets there, and the clerk has to bless that estate paying those fees. So that's why I didn't touch on it too much during the accounting phase part of this, but that's why you saw that reimbursement piece of it. It's often easier to pay things and seek the reimbursement through that petition than it is to petition for these things ahead of time and be approved. But yeah, long story short, the estate can pay for it as long as the will says it can.
Perfect. All right. And I think I misread that last question. So just to circle back, different countries, we have dealt with estates from different countries. Most lovingly worked with some lovely people from Ecuador and owned property in Transylvania County. And this actually goes to another question. We work in all of North Carolina, mountains to the coast. And I had never been to Transylvania County before, but a gentleman from Ecuador owned some farm or timberland up in Transylvania County. And I can see why. It was the most beautiful place in the whole wide world. But yes, point being, we work all through North Carolina. Most of it we're just doing via mail anyway, especially nowadays with COVID. We're not really doing a whole lot of in-person of anything. And so we're proactive enough with our clients. We're able to get mailings together and take care of everything there. Um, and then, yes, in different countries, as you can imagine, we've dealt with several administrations where individual was domiciled in another country and just owned real property in North Carolina. Happy to help in those circumstances as well. Again, it's a little more complex. You want to make sure you have proper jurisdiction and that, say, there wasn't real property in New York State and an estate has been opened up there already, and we're doing an ancillary to that. So it's a little more complex. Of course, everything is a little more complex. But that's just a piece to be aware of. One quick question. What is TBE from, sorry, we can talk in some acronyms and some lingo like no one's business. Tenants by the entirety. So that is when real property is owned by husband and wife. And one of the favorite things we love to do is just pull it up on the Register of Deeds website. You can see those deeds for most every North Carolina county, not every single one. But you can search it online. If it's to husband and wife, there's a right of survivorship associated with that tenants by the entireties type of holding of real estate there. Let's see here. Kyle, do you want to touch on this one? Is a living trust effective regarding living trust to handle out of state real estate?
Yeah, absolutely. That's one of our favorite planning tools, probably of all. So a lot of our clients, especially the way that this society is, we move around a lot. And so we probably either acquired property and kept it in another state, or maybe you inherited property in another state. That having a living trust in place where just about every state has the same type of trust rules. Basically deeding that real estate into the living trust and doing so well ahead of any notice to creditors period to satisfy all that. That's going to avoid probate. That's one of the biggest keys of that process. If the real estate's already in the name of the trust and a new trustee steps in because the grantor passes away, that new trustee has all the same rights that the grantor had in it and can either work to sell it or transfer it or basically comply with the terms of the trust, whatever it might say to do with that real estate.
Excellent. Yeah. And again, we've got a lot of questions here. This will probably be the last, well, maybe two more if we have time. I don't want to keep everyone too long. How are we supposed to start this process to be registered as the executor, appointed as the executor right now when the courts are closed? The courts are actually they were closed for a little while, and everything screeched to a halt. They are back open by appointment only. Again, for safety reasons, we're really just doing everything by mail. So you should be able to mail to the court. And again, different courthouses across the state are having things pop up if they have an outbreak or, God forbid, someone in the courthouse has been tested positive for COVID. They're randomly shutting down. But they should, for the most part, be open back up, and mailings should be getting through and things like that. So we're doing most of it by mail. Everything gets date stamped when it gets to the courthouse. Allegedly, we've had some stuff sit there for a little while, and we have to kind of politely nag. We're really good polite nags, but again, just a new norm is what we're looking at. And this will kind of be the last one. If myself and my spouse pass at the same time, God forbid, and any vehicles are left to the children, does the transfer of the vehicle ownership need to go through probate court? Kyle, do you want to touch on that one?
Yeah, the lawyerly answer is probably it depends, but I would say most of the time, yes. So if that occurs, depending on the value of the vehicle, depending on how old the children are, maybe you can use a small estate because the value of the vehicle is less than that $20,000 number. Or maybe there's DMV forms that we can use occasionally, but it depends. And if the kids were minors or something like that, we've got to do probably a full probate administration so that we can sell the car and put the money in some sort of a protected form until the children in that case reach the age of 18. If everybody's an adult, cars are worth less than $20,000. We often can handle that through a small estate, but we have to look at it in the context of all of the assets, the whole probate estate. So if the vehicle is worth $10,000, but there's $50,000 of other probate assets, we can't just do a small estate for the car. We got to do a full estate.
Yeah, yeah. It is always a little more complex than it seems. And again, we've got a few more questions out there, but I don't want to keep everyone too late. We really appreciate y'all taking the time. It was such a pleasure. We kept it all at happy faces, no sad faces, no thumbs down. But again, if you have questions, if you can't tell, we kind of like what we do. We want this to be beneficial for y'all. Please take us up on that free consultation. We're always here if anything comes up. Happy to plan proactively or walk you through if you are acting at capacity. And with that, anything else to add, Kyle?
I don't think so, but definitely take us up on the consultation. We look forward to talking to you guys. Hopefully, that you guys have seen some of those links in some of the previous emails. We've got some time set aside, so hopefully there's still some availability there. Would love to talk to you, address your specific questions. Anytime we do one of these things, it can be hard to address all of the questions. So if you guys have specific things that you need to touch on or want a little bit more clarity on, we're happy to talk to you. Otherwise, I really appreciate you guys joining us this evening. Hopefully the weather cooperated with you guys. It was storming here in Cary a little bit.
Yeah.
But thank you for joining us. Lauren, I'll let you end it.
All right. Thanks, everyone. I'll leave it that as well. We hope y'all have a lovely evening. Stay safe out there and keep in touch. Thanks again.